Happy Saturday if you're on with me live. We're going to be checking into a whole case that just happened and was filed about a week ago. Three women stepped forward to sue Gary Busey. I think that's how you say his last name. He is one of those people that I just get such a bad vibe from. And we've been talking a lot lately about trusting your gut, going over the Koberger trial, that some people can just feel something about a person. Like, there's been so many cases of people who go against their better judgment when they're first meeting somebody, and then they find out later that it was correct, that feeling, that gut instinct. And I feel that way about Gary Busey. I think he's kind of odd. I haven't seen any of his movies. He's been around for quite a while. I think he was in the first Predator movie, so maybe I saw that, but it's been a while. In 2022, he went to a big convention center for true crime, and I'm going to read you a couple things before we start. We're going to watch his first court appearance, which is what I have ready to go, and then after that, within 24 hours, he went back and pled guilty to one of them. All right, so let me read really quick. He was at a film convention in New Jersey, 2022. Three women stepped forward and said that he was touching them on purpose, inappropriately. He just had his first court appearance this past Thursday. So that is going to get the ball rolling. I believe he will have a trial, a grand jury. He should anyway. But when this first rolled out, he said that he was guilty on all counts. And I'm getting another video ready to go really quick. I want to show you guys this one first. You know, he appeared before the judge. He said, no, like, I didn't do anything like that. I don't know them. Like, just pushing it aside. I don't know what made him change his mind, but I'm happy at least for one of them that he admitted to it. And I believe the other two girls are still going to go after him. So if you're like me and you really don't know anything about him, he's very bizarre. Like I said, bad gut instinct about him. But we're going to watch a video that is trying to find different scenarios of him acting very weird. And this is just one of many. So let me know if you need volume up or down. That's not the right one.
Not everyone's interested in the Oscars. This happens to be my business and my industry. So I'm here to celebrate those that are nominated tonight. And as far as I'm concerned with the nomination, everybody goes home a winner once you're nominated.
Tell me, yay! Good move. Can I just ask you quickly, what are you up to at the moment, Gary?
I'm up to about 195 pounds. Good try.
Have a very good night. Enjoy yourself.
My projects are confidential and very lovely. And when you see them, you'll be very surprised.
You working for the CIA?
No.
MI5?
MI5?
FBI?
No. I'm working. I can't tell you.
You'd have to kill me, right?
Yeah.
Good move. I like that.
I know. Okay. Don't report this to a doctor. Okay?
Have a great night.
I won't forget this one.
No, good interview.
You are great at what you do.
Thank you very much.
Because you got stuff out of me I didn't know how to give.
Thank you, Gary.
So bizarre. To be fair, in 1988, he actually got in a motorcycle accident. It left him with a fractured skull and permanent brain damage. So there are issues going on that could affect him in that way, as we just saw. Some of the times I thought he was being sarcastic, but then he was pretty serious. And this, I'm like, oh no, he's just being weird. But that may play into it. We're going to go ahead and watch the first court appointment. And I believe it's only like 8 minutes long. It's not super long. And then we'll hop straight into the next day and him confessing to one of them.
Primary argument is that if a grand jury, why not give it? There was no difficulty. For a second, firstly, I know I think investigation kind of segues into this whole thing, because the failure of the police to actually reach out and question Miss Higginbotham, who was a direct line of sight possible witness, that's an error that affects, in my estimation, the integrity of the grand jury presentation. There was no reason to do that, to not do that, to not question her, or at least for the prosecutor eventually not to put a sworn affidavit of hers, which creates a whole lot of doubt about whether Mr. Busey did anything wrong or not, whether it's inappropriate or not. As I agree with the court, that's a jury question, inappropriate, but we can assume, I believe fairly, that neither of these individuals would consider appropriate some type of sexual contact that they observed. I think that's beyond cavil that would be the case. So in the end, it's I believe under State versus Hogan and the duty of the prosecutor, again, I don't want to reiterate, the court's well aware of those announcements and declarations about the duty of a prosecutor. There was just no harm in giving the grand jury, and no extra time. They simply had to put into evidence these two affidavits, even if they didn't take the time to get statements. By the way, law enforcement didn't even take a written statement for Mr. Philpott, another alleged possible eyewitness. So for that reason, I think the faulty investigation, if you will, contributed to the eventual unfairness that occurred during the grand jury presentation. I understand what Your Honor is saying, and there's some trial issues here, but we're saying is the case should not go to trial because the grand jury was not given an accurate, full picture of the evidence in the possession of the state. I'm assuming my predecessor counsel in sending these affidavits to the prosecutor's office, which the prosecutor's office has acknowledged receiving, I'm assuming it was sent in order to demonstrate that the evidence did not support a charge against Mr. Busey for these offenses.
So you're saying to the court that each of these affidavits, the entirety of these affidavits should have been given to the jury?
At the very least.
That's what you're telling the court.
At the very least.
Okay. Okay, Mr. Carmi, I'll hear from you.
Thank you, Your Honor. Your Honor, the state's response to the motion of the defense is really twofold. First, that the information that counsel has discussed, the two affidavits are, number one, not clearly exculpatory. Your Honor, I just point out, I'm sure the court has had an opportunity to review the state's brief, and I'd rely on that. Just a couple points from Hogan, which is the primary case that we look to with respect to motion dismissing indictment. Hogan court indicated with respect to exculpatory testimony that exculpatory testimony of one eyewitness is not clearly exculpatory if contradicted by the incriminating testimony of a number of other witnesses. So in this case, we have that situation where we have certain testimony that counsel suggested the state should have presented to the grand jury, which is flat out contradicted by at least 5 of the victims, and partly by the defendant himself in his own statement to police. This Hogan court also indicated that exculpatory evidence should be analyzed in the context of the nature and source of the evidence and the strength of the state's case. I think one of the reasons why the state did not present specifically the affidavit of Mr. Philpott is that Mr. Philpott is an employee of Mr. Busey. He was Mr. Busey's manager there was an indication that he may have been present with Mr. Busey at some points during the convention, but that his statement, I'm not saying that, what he's saying in the affidavit is false, but there's certainly potential bias there in favor of Mr. Busey and having Mr. Philpott say, well, he didn't see anything. And that's part of the reason why the state's argument is that this testimony is not clearly exculpatory. This information is not clearly exculpatory. Is we have two apparent witnesses who are saying basically that they didn't see anything. That doesn't mean that it didn't happen. And that's information that's been contradicted by a number of witnesses in this case. So that's really the primary. The first point is that it's not clearly exculpatory evidence. The second point is, Your Honor, the state essentially did present this evidence to the grand jury. Even if the court were to find that what counsel's suggesting in these affidavits is clearly exculpatory, the essential substance of what's in the affidavits was presented, which is that the photographers who were present, or at least one, if not more photographers who were present, did not see the conduct occur, which is exactly what the state did.
All right, if you're just joining us, we're watching this Zoom hearing. Gary Busey, the actor, of course, is...
As I go to the next video, how old do you think he is? You don't have to write in the chat if you don't want to, but I'm curious to know, how old do you think he is currently? If you have any guesses, think about your answer, because I'm about to tell you. He is 81. This whole thing, these women coming forward, he was 78 doing stuff like this. It's unbelievable. It is unbelievable. You would just think that by that age, people would be respectful and not doing weird, bad things. But nope, evidently, age is not always a factor. All right, I'm going to go ahead and get this started.
Mr.
It was a 5-count indictment, Your Honor.
So he's pleading guilty to count 1, so the remaining counts 2 through 5 are being dismissed, right?
Those will be dismissed at sentencing, yes, Your Honor.
Okay, so it's a term of probation, fines, no contact with, what are the initials for that person in count 1?
Your Honor, the victim, hold on one second, Judge. The anticipated conditions are really that the defendant have no contact with any of the victims.
If any of the named...
Correct, Your Honor. Any of the named victims in the indictment. If Your Honor wants, I can put the initials on the record.
Can you do that, please?
Sure.
I think that would be better.
Yes, Judge. Count 1, victim being AD.
Okay.
Count 2 is JE. Count 3 is MH. Count 4 is BB. And count 5, victim's initials are MS. The defendant would agree to have no contact with any of those named victims as part of the plea agreement.
Okay. Counsel, those terms as stated, Mr. Zwillman, is that correct?
Judge, we agree to the no contact, but I disagree with most respectfully for identifying the individuals in counts 2 through 5 as victims, since those cases are being dismissed. But it's just a technical matter. I don't think they remain victims if they're being dismissed.
Well, that's not unusual when there's resolutions and there's more than one named in an indictment. That's not unusual that the state is asking for the terms to be conditions, and I can't control the conditions, that there's no contact with anyone named in any counts. So what do you want to do with that?
We agree to that, Judge. I just don't want the record to reveal that he's pled guilty to anything other than count 1.
It's not going to, why would it do that? Why would it?
Well,
It wouldn't.
because the term victim is still being used for counts 2 through 5. No, not a problem, Judge.
Now, Mr. Busey, we're in a courtroom, although we are Zoom. You can't eat or drink in my courtroom, although we are on Zoom. You're before a judge. And when you're before a judge, you act accordingly. No eating.
No eating, no drinking, no talking to somebody off camera. He was doing all of the above.
No drinking in my presence. You understand, sir?
Yes, ma'am. Thank you, Judge.
Okay. Now, Mr. Zwillman, those terms are stated by the prosecutor. It sounds like you are reserving your right to make what's called the warrant argument regarding the probationary agreement that's going to be entered. Is that correct?
Yes, Judge.
Okay. Now, the other terms as stated by the prosecutor, are they correct regarding this colloquy, this guilty plea?
Yes, Judge.
Okay, Mr. Busey, please state your name and raise your right hand for me.
State your name. State your name.
State your name, sir.
My name is William Gary Busey, B-U-S-E-Y.
Okay, do you, sir, swear or affirm any testimony you give the court shall be the truth?
What? I'm sorry?
Do you swear or affirm that any testimony you give the court shall be the truth?
Yes, ma'am, I do. I confirm that.
Okay. Now, it is my understanding you wish to plead guilty to a fourth-degree sexual contact, criminal sexual contact. Is that correct?
Am I pleading guilty?
Yes.
No.
Yes.
Okay.
I am?
No.
Okay. I am.
No. No, that's not how it works. Listen to me, Mr. Busey.
Huh?
Did you talk to your attorney about how you want to handle your case today?
Yes.
Yes.
But I don't want you to say yes, and I don't want anyone to tell you what to say. You need to say it on your own, sir.
Yes.
Okay, now do you wear some type of hearing assistance,
Yes.
Mr. Busey? Okay, do you have it on now? Okay, do you have it up loud enough so you can hear? Are you
I
able
have
to-
it up as loud as it'll go.
Okay. Now, this is my question. Do you wish to plead guilty to a criminal sexual contact today?
Yeah.
Now, I wonder if there's something else that we could do that allow Mr. Busey to hear a little better. Are you having a hard time hearing altogether, Mr. Busey? Are you hearing me
Yes,
some?
Yes, I have hearing aids and they are working, but they only go so high.
I understand. And are you still having some trouble hearing me,
No.
even with your hearing aid on?
No, I don't. I hear you fine.
Okay. So my question is again is, do you wish to plead guilty to a fourth-degree charge of criminal sexual contact? Yes or no?
Yes.
Now, before you decided to plead guilty to that charge, did you review that charge with your attorney?
Yes.
Did you have a chance to read the police reports with your attorney?
Yes.
Has your attorney answered all questions that you've had?
Yes.
Are you satisfied with the advice he has given you?
Yes.
Have you had enough time to meet with your attorney?
Yes.
Now, this is my understanding of the plea agreement. It is my understanding you will be pleading guilty to count one of the indictment. Count one charges you with fourth-degree criminal sexual contact. On your sentence date, the state is recommending I sentence you to a term of probation. Could you hear all of that?
Yes, ma'am.
Okay, and do
Yes,
you
Judge.
understand? Okay, you understand?
Yeah.
Okay, now probation will be anywhere between 1 to 5 years. The length of probation and condition of probation will be set by me in my discretion. Do you understand that?
Yes, ma'am. Thank you.
Your fines will be...
Well, we had understood this would be a pre-trial hearing. It's now turning into a guilty plea. I'll tell you.
So that might have been a first. I love when the judge is going through and basically saying, is this what you've decided on? You're pleading to this. No one's forcing you to. Just like all the things that they have to ask. And he's like, no, I'm not pleading that. And then you hear the voice off camera saying, yes, you do. So pretty funny. Hopefully with whatever goes on with this, I'm assuming with the plea, they are not going to trial. That was their intent for it. I hope that the one victim, at least, that he is admitting to, I hope, however she was doing that, whether it was a civil case or something else, I hope that she gets some justice in this because he admitted it. I'll keep an eye out and see what the other two women do, if anything. But I would imagine at this point, since there wasn't a lot of evidence and it's been 3 years, it might not go through. But at least they got one. Not that that's great justice or anything, but it's something. All right, I'm going to be coming back on here very, very soon because I am going to pick up the Nicholas Kesotis trial. They're on day 4. So we should be able to catch up easy. The first day is mostly just waiting, so I can skip through. We don't have to wait hours or anything. So we should catch up fast. But if you haven't heard anything about it, Nicholas was accused of dismembering his wife. I think it was day 4, so we're a little ways away, but I saw that family members were coming up and testifying, and there's a lot of moving parts I think will be interesting. So if you're bored and want to hang out with me, I'll probably be back on in like 10-15 minutes, and I have work to do on my computer, so I will be here watching and working. All right, as always, thank you so much for watching.